Okay, call this meeting to order. The meeting number 29 of the Standing Committee on Canadian Heritage. Today we do have some witnesses here, but just previous to entertaining the witnesses, I've been requested by Mr. Boulanger that we might do just a little bit of committee business first, and that's to deal with his motion from December the 11th, that representatives of the Court Challenge Program be invited to appear before the Standing Committee on Canadian Heritage. Just before we deal with that, there's also been another request from an individual just today that to come before this committee. I was just wondering if it could be done on that same day. That would be about the only way that we could handle this other. So I'm just looking for some.
Mr. Chairman, I don't know who the other one is, so I'm not prepared to, blindly say yea or nay, because all the other witnesses were suggestions of members of the committee that we'd agreed upon. So this one, not knowing who it is, I find it's difficult to ask members to agree. The other one is, and perhaps notice what should be given if it's a member of the committee that's making that recommendation, then we can dispose of it. Okay.
It's from Maria York, Director of Research and Education, Canadian Institute for Workers, founder and acting president of Canadian Council of Injured Workers. So that's who has made the request to the clerk and myself here today. Again, how do you want me to handle that?
Well, Mr. Chairman, I put a motion forward in due notice, and my sense is that it would be important to have, and I didn't think we'd be getting into a debate here, but it would be important that a meeting be given to the Court Challenges Program, because the reason I've put forward this motion is because there have been a number of things said that I think need to be cleared up, and they, if anyone, would be in a position to answer some of the questions that have arisen. That's why I put the motion forward, so that we can have a full picture.
Okay. Yes, Mr. Abbott.
Just a point of clarification. Are we talking about officials from the department, or are we talking about people who were on the committee? I'm
saying representatives of the Court Challenges Program.
But what does that?
That is not the departmental officials, obviously. Okay. Because the Court Challenges Program is a standalone program, arms-led, with its own board. They'll determine who they wish to have as their representatives.
Good. Thank you.
Okay, then we will vote on Mr. Boulanger's motion that representatives of the Court Challenge Program be invited to appear before the Standing Committee on Canadian Heritage. And that meeting then would be Tuesday, January the 30th. All those in favor? Okay. Okay. Pass on division? Okay. Carried on division.
Chairman.
Okay. So welcome to our witnesses here today, and thank you for coming. And I don't know who's to go first, but I will go by order. Then here on the thing, Mr. Kevin Rollison. Would you like to make your presentation, sir, please?
Yep. Thank you very much for allowing my daughter and myself to appear before this committee. I believe it's important for politicians to look into the faces of the people who are affected by the laws this country passes. That's why my family paid for my daughter to come down here. We've since found we may have a little bit of a refund, which is wonderful. Unlike the other people who have given submissions before you, I am not the head or representative of a group or organization which has been helped or is being helped by the Court Challenges of Canada program. I'm simply here as the father of a child, not just any child. As you can see, I'm the parent of 9-year-old Mary Rollison McCauley, a child who was born with multiple disabilities and medical issues, a child who's only alive today because of doctors and her own strong will to live. she's a child who has been helped by the Court Challenges of Canada program. It is for that reason both Mary and I have traveled all the way from Winnipeg to Ottawa on behalf of our family and all families with children with disabilities to ask for your support in continuing to fund and keep in existence the Court Challenges of Canada program. When I was denied the bulk of my parental leave benefits in 1998, I was forced to go back to work after only receiving 4 weeks of benefits through employment insurance. What the Court Challenges program enabled our family to do was to hire a lawyer to challenge the validity of the federal legislation under Section 15 of the Charter of Rights and Freedoms on the basis of age, disability, and family status. The legislative changes to the Unemployment Insurance Act at that time resulted in the loss of the bulk of my parental leave at the time it was most needed, when Mary came home from hospital. Instead of receiving my 15 weeks of benefits when my severely disabled child came home from hospital at 10.5 months of age, the new Employment Insurance Act limited me to taking that time within a year of her birth, resulting in a loss of 11 weeks of benefits. I had, on the advice of medical professionals, waited until Mary got home from the hospital to take my leave, as that was when it was deemed to be when Mary would need it the most. Our constitutional challenge against the Employment Insurance Program was successful, but without the help of funding from the Court Challenges Program, our constitutional challenges against the Act would most likely not have been successful. We not only were successful in our challenge on all 3 grounds of discrimination, but just as important, as a result of the challenge being launched, the federal government today amended the Act prior to the hearing. Last September, in announcing a plan to slash $1 billion from the federal budget, of which cutting the Court Challenges program represented $5.6 million of the savings, Treasury Board President John Baird was quoted in the media saying the program wasn't meeting the priorities of Canadians or providing value for money. As well, in talking specifically about the Court Challenges program, Mr. Baird said the federal government was no longer interested in funding opposition to legislation it believes is right. I ask all of you to look at Mary, and along with her, all of the Marys with disabilities across the country, whether they are children or adults. I ask you to ask yourselves whether her constitutional rights aren't meeting the priorities of Canadians, whether fighting the discrimination against Mary and others with disabilities is not providing value for money, and above all, whether any of you really believe that there will never be a future law passed that will not discriminate against Mary and others with disabilities across the country. With our family situation, it didn't matter that our situation arguments actually persuaded the federal government to change the law to cover people like us before we even had our day in court. But after the government amended the legislation, because it wasn't retroactive, it still continued to fight our challenge to the very end. That's why Canadians need the Court Challenges program. Do I really think the federal government purposely meant to discriminate against newborns with disabilities? No. Do I think the federal government purposely changed the law to discriminate against newborns with disabilities? No. But do I think it's extremely hard for politicians and bureaucrats to know all of the ramifications that may come from their decisions to amend or create laws? Well, yes. As the umpire who heard our case said in his decision, and I quote, "By oversight or otherwise, the Commission strayed from its legislative objectives. This, in the circumstances, is not surprising. Legislating in the area of social legislation is both difficult and challenging. Court challenges multiply. Pressure groups and social changes place considerable pressure and strain, not only on government, but also upon senior public servants who struggle to keep abreast of all developments." Unquote. It's not wrong for politicians and bureaucrats to admit mistakes and infringements on constitutional rights, but unfortunately, as in our case, the government never did admit what they did was wrong, forcing us to proceed with the challenge. What is wrong is not to allow individual Canadians who've had their rights infringed to be able to make and mount a reasonable and meaningful constitutional challenge in a court. That's especially so when many of us are individuals who are still living with the discrimination. We're trying to fight for our constitutional rights while still carrying on with our lives. Mary's needs did not end the day she was released from hospital when she was 10.5 months old. They didn't end when she turned 2, and they certainly haven't ended now. If I had had to continue the constitutional challenge by myself, without the lawyer I was able to hire through funding by Court Challenges, every minute, every day, every week after work that I would have had to spend to mount that challenge would have been time taken away from my daughter and our fight, literally, to keep her alive. The Court Challenges program put me on equal footing with the federal government. Whether I was with a lawyer or not, the federal government had a team of lawyers fighting against me, bringing to bear the full resources of the state. What individual without legal training could possibly have made a meaningful defense of the issue? Even with a lawyer, the legal battle, as many do, waged so long. Mary was in elementary school, enrolled in grade 1, when the decision was finally made that the government's employment insurance program had discriminated against my daughter and myself through her disability. But the length of the legal battle didn't bother us because it was never our sole purpose to fight for just our family's rights. As we have discovered during our 9 years of being intimately involved with disability issues, when an issue affects one person, there are many more that are also affected. In our family, Mary and I were not the only ones affected by the employment insurance decision. Because I could not be home but had to work, it meant my wife actually bore the brunt of the EI decision. At that time, Mary was connected by tube to a feeding machine 24 hours a day, 7 days a week, and there were numerous times during the day she could have aspirated into her stomach, into her lungs, and she could die. My wife and I were taught how to do CPR and given a portable suction machine. Mary could not be left alone any minute of the day or night. Someone had to be awake with her 24 hours a day. Our eventual success and our eventual repayment to compensate me for the benefits loss was still put to good use earlier this year when Mary required more open-heart surgery in Toronto and my wife and I were off work for 11 weeks. From where we sit, we believe the Court Challenges program has become a political football subject to the ideological whims of the political party and government. But the rights of Canadians can be infringed no matter which party was in power. It was actually a Liberal government which changed the unemployment insurance law, which caused my family to be discriminated against. It could just as easily be a Conservative government, an NDP government, or a motion originated by the Bloc Québécois. To put it bluntly, discrimination can originate anywhere on the political spectrum. In our situation, we were fighting for 11 weeks of parental leave. In terms of benefits, I lost about $6,000. On an individual basis, it would have made no sense for us to pay a lawyer more than $70,000 to fight the discrimination unless we were independently wealthy or crazy, and I can assure you, we are neither. But as with many other issues of disability, we knew there were other Marys out there, children who were born with such potentially fatal medical problems that their parents should have the right to choose whether they use the benefits while the child is still in hospital or at home. That's the beauty of the Court Challenges program. They only take on constitutional challenges that can affect many people across the land. As the umpire who decided our case, we didn't know we had funding through Court Challenges, said, quote, Rawlinson brought a deficiency to the attention of Parliament which, while it has since been remedied, he should not have to bear the cost of doing so in order to obtain the benefits to which he was entitled, unquote. Unless this program is reinstated and retained, constitutional challenges will be something only the richest in society can afford. That's wrong. Discrimination cuts across all classes and incomes. I never would have dreamed I'd ever have my rights infringed upon. Our family simply became the victim of discrimination because a child was born and she had disabilities. It's sad to know that the future parents of a disabled child or anybody with disabilities may not have the Court Challenges program to turn to unless you help keep it. Like me, other Canadians could only be the birth of a child away from discrimination. Don't take away the federal program that helped us and all Canadians who are in our situation. Both myself, my daughter Mary, and my family, thank you for your time and your attention. I'm assuming you might have got copies. There's also a brief from my wife, Gail McCauley, that should be part of your package. I'd urge you all to read it. It's from Mummy's point of view, and she's pretty straight to the point, just what the brunt was that she faced when I was away. Thank you.
Great. Thank you very much. Our next presentation is from Louise Acton.
Au point.
Okay. Sorry about that.
Bonjour, Monsieur le Président.
Good afternoon, Mr. Chairman and members of the committee. My name is Louise Aucoin, and I'm the president of the Fédération des Associations de Juristes d'Expression Française de Common Law, the FAJEF, the French-speaking Lawyers Common Law Association. Thank you for having invited me to testify before your committee today on the issue of the Court Challenges program. Our federation includes 7 associations of French-speaking lawyers, and we represent more than 1,200 jurists. The FAJEF promotes and defends linguistic and rights of the minority community francophones in the justice sector in Canada. The association is a member of the Federation of Francophone and Acadian Communities of Canada, the FCFA. First of all, our Federation wishes to emphasize that it supports fully the comments made in the brief tabled last week by the FCFA, particularly those dealing with the decisive role that the Core Challenges program has been able to play in promoting the development of minority francophones, as well as in the full recognition and promotion of the use of French in Canadian society. Furthermore, access to justice in French and legal bilingualism have made a great deal of progress because of legal challenges that have benefited from the support of the Court Challenges program in cases like Bolac and Donny Doucette. By abolishing the funding to the Court Challenges program, there is a risk that at best there will be stagnation, and in the worst scenario we risk losing ground in terms of language rights, which does not augur well for the respect of Part 7 of the Official Languages Act of Canada, and in our case, for the improvement of access to justice in French outside of Quebec. Our Federation is very concerned by the impact of the termination of funding and what that will have on the ability of Francophone and Acadian communities to continue to defend their constitutional rights. Furthermore, we have already heard about certain groups or particular Francophones who will no longer have the means to defend their linguistic rights before the courts. Their situation can be summed up as follows: no funding, no access, no defense of linguistic rights, and even less progress in this area. Furthermore, the FAGEF is already a victim of this situation, as we cannot, for financial reasons, even consider intervening, for example, in the Paulin case, which is dealing with the role of the RCMP in New Brunswick. But it will probably end up dealing with the RCMP's situation across the country, and it will be heard by the Supreme Court of Canada probably in 2007. As well, the abolition of the Core Challenges program provides less benefits for Canadian citizens, particularly for linguistic minorities in Canada. Why? Because a Francophone who chooses to live in a province where they will be in the minority would perhaps find themselves obliged to pay out of their own pockets to have their linguistic rights and their constitutional rights respected. That has already cost several $100,000. A Francophone minority, therefore, has linguistic rights, but only insofar as he or she is ready to pay tens or hundreds of thousands of dollars to ensure that they are respected, which Anglophone majorities do not have. So, as well as promoting the interests of Francophones in Quebec, it's not encouraging to think that the linguistic rights of Francophones are not so appreciated elsewhere in Canada. On the contrary, by getting rid of the funding for, or ending the funding rather, for the Court Challenges program, the message that has been sent to minority Francophones is the following: it's your language, it's your problem, and you can pay for the protection of your French language rights yourselves, and it's not in the public interest by the federal government to support it. If the elimination of funding to the Core Challenges program is a result of the fact that certain groups or individuals are not receiving funding, our Federation has no problem with the mandate of the Core Challenges program being broadened so that it is not done at the expense of the disadvantaged and language minorities, as has been pointed out by a previous witness. If the elimination of this funding is done on the principle that the federal government should not contribute to challenges to itself, they should amongst other things, reform the tax system because, for example, the media can presently claim business expenses and then reduce their taxes in the case of a constitutional challenge against the federal government, and by deducting these costs as a cost of doing business. If the federal government subsidizes this indirectly through some businesses, at least through the tax system, why would it not also help Canadian citizens, including Francophone minorities, to protect their rights? The Federation does not believe that the benefits of Canadian citizenship should be reserved to the wealthy and to Francophone and Anglophone majorities. So I thank you, and I'd be pleased to answer your questions and comments afterwards.
Yes, thank you. My name's Chantal Tai. Thank you very much for inviting me here today. I'm here sitting as a representative of LEAF, the Women's Legal Education and Action Fund, and we have historically been a significant beneficiary of court challenges funds. I sat for 7 years on the National Legal Committee of LEAF, which determines the litigation and applies for funding and determines the litigation strategy. I was then nominated by LEAF to run for the Board of Directors of the Court Challenges Program. I took a leave from the National Legal Committee and served for 7 years on the board of the Court Challenges Program. 4 of those years as chairman of the board. I am the most recent past chair of the Board of Directors of the Court Challenges Program, and I'm now, since last year, actually just since recently again, back on the National Legal Committee of LEAF. I appeared before the House Standing Committee on Justice and Human Rights about 2 weeks ago, following the presentation by the Canadian Taxpayers Federation on the Court Challenges Program, and was astonished to hear that group say that eliminating the Court Challenges Program was promoting equality because it leveled the playing field. So I'd like to address my comments to that comment, which I must say astounded me to hear. It astounded me for a number of reasons, primarily because, in essence, it's equality with a vengeance, as the Supreme Court of Canada has said on occasion. And it also presumes that treating everyone the same is what equality is all about. That is, quite frankly, an outdated notion, one which was prevalent in the 1960s, and it is a thinking that takes us back 40 years in complete ignorance of the developments in human rights and equality legislation in the past 40 years. It is a vision of equality that says when you treat everyone the same, that's all you need to do. That is called formal equality, treating everyone the same. Unfortunately, everyone is not similarly situated. One must look at the impact of the decisions upon affected people. That statement by the Canadian Taxpayers Federation, which seemed to find favor with government representatives, left me with 2 possible conclusions. Either those members who supported that decision or that approach clearly have no understanding of what equality is and have no knowledge of developments in equality jurisprudence and thinking in the last 40 years, or they do understand the difference and have deliberately engaged in doublespeak to confuse the issues that are before us and, in effect, merely disagree with the vision. What is the vision? The vision is not some invention of LEAF or the Court Challenges Program, although we do admit we may have contributed towards the building of that vision. It is the vision that the Supreme Court of Canada has said our charter, which is the law of this land, mandates. It is a substantive equality. And if you apply that vision to the elimination of this program, it cannot be justified under any definition of equality. What does this program do? I think Mr. Rolliston's comments were very apt. He thought it was important to show you the face of someone who has benefited from the Court Challenges program. Well, the Court Challenges program brings the faces and the voices of disenfranchised, marginalized, and discriminated people in this country before the court. Because, unfortunately, judges labor under the same handicap that parliamentarians may labor under as well, and that is they do not have the lived experience of disadvantage that needs to come to before the courts when the courts are adjudicating rights under the Charter. It is absolutely essential that those voices be heard, and the Court Challenges program provides extremely modest funding to groups who are identified as disadvantaged in our Charter, so their voices can be heard. Without their voices, we will have a thin and impoverished view of equality. Unfortunately, we may end up with a view of equality back in the 1960s, which says treating everyone the same is equality. It's also extremely important that the current structure, or a structure very similar to the current structure of Court Challenges program, is maintained. That structure gives the disadvantaged groups themselves significant say in the priorities and the direction and the allocation of funds on a test case basis to litigation. People who suffer disadvantage must play an important and active role in remedying that disadvantage. Eliminating funding to the program does none of those things. It silences voices. It makes our Supreme Court a bastion of the rich and the privileged, not a defender of the rights of the disadvantaged. That's not what our Charter says. Our Charter says that we are to have those rights. If we have no access to the courts, we will not enjoy any of those rights. Thank you.
Okay, thank you very much. Mr. Boulanger.
Thank you, Mr. Chairman. Thank you very much, all of you, for your presentations. Merci beaucoup. I have a very quick question that I've asked of all of our witnesses who have had support from the Court Challenges program. In determining the choice of your lawyers, once you had funding, was the political affiliation of these lawyers a matter of any consideration?
I can speak for Leaf. We don't even know the political affiliation of our lawyers. It is completely immaterial. The way we choose our lawyers, the way we choose our cases, is very much in line with the contribution agreement for the Court Challenges program itself, which is the position that we take must advance women's equality. And what that means is that's not an ideological concept. That is, we start out and our whole process involves consultations with the groups who are affected, academic consultations, subcommittees with academics, people who have the lived experience, and litigators. And it's out of that process that we decide what is in the economic interests of women.
Thank you.
What is in the physical security interest? We don't start with a preconceived notion of what equality is or what position we should take. We look at the facts and we say, what best helps women to get economic security and physical security? And when we choose our lawyers, the funding that the Court Challenges program provides is modest.
I've only got 5 minutes, so I'm sorry. I'm going to ask the questions to be, I kept my question very short. Perhaps the answers could be succinct as well. Madame Aucoin?
Go ahead.
Je dois vous dire très honnêtement.
Quite frankly, language rights are an area in which there are very few practitioners. So often these lawyers who work in this area do so because it's a passion for them. So I have to say that I have no idea of their political affiliation.
We were just, because it was a charter challenge, we were just referred to a person who specializes in charter challenges. I have absolutely no idea.
Thank you. Now, the reason I asked the question is because in defending the cuts, the Prime Minister used as one reason that the government didn't want to be funding Liberal lawyers. And I wanted to know whether or not that was a consideration to the people who had received funding. So thank you for your answer. Mr. Rollison, on Monday we heard 4 witnesses who had opposed or supported the cancellation of the Court Challenges program, maintain that if there's a challenge to be made, it should be funded by the community or by the groups themselves. Would that be a reasonable proposition in your case, sir?
Coming from a standpoint of disability, we're members of several disability organizations in Winnipeg and Manitoba. None of these groups that we're part of could in any way, shape, or form hire a lawyer for us and take on a challenge like this. They barely have enough money for programs they themselves run to have a legal challenge. That's above and beyond what they could possibly afford. It's the same as us as an individual family. There's no way we could have afforded something like that.
Thank you. Madam Tai?
Yes, absolutely. One of the unifying and defining features of many forms of disadvantage is poverty. That's what defines it in our society. People who are marginalized and don't have access to resources, power, and political power are defined by poverty. That's very true of most of the disadvantaged groups. Most of the lawyers that we have actually act pro bono, because even with the Court Challenges money, it's not enough.
Pour les minoritaires ou les francophones en situation.
For Francophone minorities, as a general rule, it's extremely difficult to grant such litigation, to provide a grant to such litigation. You made an interesting point, Ms. Aucoin. If we were to scrap the program, you said that we should overhaul the corporate tax system. Corporations can deduct their legal costs from their revenue. So that begs the question, should non-profit organisations be able to submit receipts for tax purposes to pay for legal fees? No, that's not possible. Thank you. Mr. Malo. Thank you, Mr. Chair. The definition you gave us of equality was very interesting to my mind, and I'd like to go deeper into this analysis. Can you describe what justice is to you?
Justice is a very broad concept, but in this case, access to justice is, I think, what's most important. And when you deny people access to the courts, and even though we may have a charter of rights, unless you have access to the courts, you have no access to justice. And justice includes in this country charter rights, freedom from discrimination, equality rights, Section 7 rights on security of the person. So justice is a very important part of this. It's the ability to both defend against and assert positive rights.
Madame Aucoin, tout à l'heure.
Ms. Aucoin, earlier you said that there are a number of groups facing a lot of trouble when it comes to defending their rights already. Can you go further and explain which cases currently may not be heard before the courts, which may cause a lot of harm to individuals? Well, I referred to the Paulin case, which will define the RCMP's role everywhere. Only in Quebec and in Ontario is the RCMP not used as the regular police system. So the Paulin case will deal with the RCMP's role in New Brunswick. But as New Brunswick is the only officially bilingual province, where language rights have been made constitutional, well, things will be quite different for the other provinces. It will be another kettle of fish. So it's very important that these provinces be able to defend their rights before the Supreme Court in this area. What would the Paulin case's ramifications be if it wasn't actually heard before the courts? Well, we have different rights in each province. So if you want a united Canada, it won't help us to achieve this if one province gets greater access to rights than others. Do you think that the Court Challenges program has lessened legislators' power and given more power to the judiciary? Answer no.
We have a democratic government. We believe in democracy, but our democracy is a democracy which includes majority rule with protection for minority rights. The role of the court is the protection of the minority rights within majority rule. That's the court's role. That's what the Constitution says. The Court Challenges program hasn't invented that. The Court Challenges program merely provides the means for the protection of minority rights. That's the role. It's not the Court Challenges program that has invented that.
I have a friend that said access to courts are the actual foundation of our access to justice. We need access to the courts if we want to have our rights upheld. Well, if I've understood you correctly, the CCP is something which is quintessentially democratic. Absolutely. Thank you, Mr. Chair. Thank you, ladies and sir.
Mr. Chair. Thank you very much for coming today as well. I'll start with Mr. Rollison. You mentioned in your brief that you had some support from the Court Challenges program, but the federal government that was actually fighting to take away rights that you should have readily been accorded had a full team of lawyers. Could you give me any estimate of what taxpayers paid to fund the federal government actually not trying to support the rights that you had a right to?
Well, I can only guesstimate as a parent, but in the courtroom itself, they had two federal government lawyers there at the table. They had an assistant. They had somebody sitting in the audience as well. The team had flown from Ottawa. This wasn't a Winnipeg-based lawyer. There was X amount of court days. We were in court for 2 days, and who knows how much money they spent to get to that point. It would have been in the tens of thousands of dollars at least.
So the federal government paid tens of thousands of dollars to try to stop you and Mary, your family, from having rights that normally should be accorded to you. So in a real sense, what this debate is about isn't about subsidizing people through the Court Challenges program. It's trying to have a level playing field so that the huge subsidies that the federal government already implies, the federal government in this case being conservative, to try to squash rights is actually counterbalanced by some ability by individuals and Canadians to fight back.
Yeah, well, as I say, they have the resources to stay with them. We were only an individual parent who was trying to get on an equal footing. And as I said, I did challenge it before the tribunal, the Board of Review. They couldn't, for one thing, they couldn't hear constitutional issues. For another thing, I got squashed, to put it bluntly, that parents, the vast majority of parents across the land would not be able to come up with a constitutional challenge. And we believe we're middle-class people, that there's an awful lot of people with children with disabilities, with adults with disabilities, that are nowhere near the poverty line. They're lower than us. Think of them if they had to come forward like us to mount a challenge. There's absolutely no way that.
You could not have done it without the Court Challenges program. So with the elimination of this program in a few months, another parent in similar situation would simply have to bow to the government, no matter how mean-spirited and how.
That a parent would have to do what we did, which initially we went to our local MP. Then we went beyond that. We went to human rights. We were told that actually the change of the policy was okay. It made it more equal for us. we still disagreed. So we finally found a lawyer that was willing to apply for court challenges funding and went forward. But until we had that, every step of the way we were either denied or we lost. It was only once we got the court challenges funding and got a lawyer and went through that process, finally things started happening. We actually found during our challenge that when we did a Freedom of Information request, we got back documents from the federal government here in Ottawa that were our documents that we'd had beforehand, that, with our names blacked out. It showed that the only time when we started actually making some progress was when we had a lawyer funded by court challenges. It wasn't before that.
Thank you for that. Now, coming to Ms. Tai, we have a situation really where that ability to fight for equality rights is being taken away. Is your sense that we're moving towards an American-style justice system where essentially, unless people have money and financial resources, they wouldn't have that access to equality that we should be maintaining and enhancing in this country?
Well, I certainly agree with you that if you eliminate the program, we've had a devastating parallel cut in legal aid in this country as well. So it's a kind of like a double whammy. And the difference, I think, between Canada and the United States is that litigation does proceed in the United States on many constitutional and test case issues, but they have a much more highly developed what do you call it, foundation, money-giving organ in the United States that is able to pick up the slack where the government does not give money in a way that it's just not that developed in Canada. In terms of non-profit foundations giving money out for litigation, the same way it is.
But so in a real sense, because the American system is far from perfect. In fact, there are a lot of concerns about the lack of accessibility of the court system in the U.S. But what you're saying is we'll be even worse.
Yes, it'll be worse here because there isn't even the fallback of donor foundations that might give money for these kinds of things. It's just a very different tradition in this country. So when you eliminate the access to justice through public funding here, it leaves a far bigger hole than it would in the United States.
Okay, ma dernière question, c'est Madame Aucoin.
My final question is from Ms. Aucoin.
Mr. Fast.
Well, thank you, Mr. Chair, and thank you to all three of you for appearing before us today. First of all, a question through to Ms. Tai. You've mentioned that you sat on the board of CCP for 7 years?
That's correct.
Is that correct? Have any other members of your organization in the past sat on either a panel or the board or an advisory committee of the CCP?
The CCP is structured such that it is the membership are the people who sit, who have positions on the board. So, for instance, there's an equality side and
I understand that.
Language side.
Just so you know, I've researched the structure and I understand who sits on it. My question was, have there been other members of your organization that have also been involved in CCP, either on a committee or a panel or on the board?
Yes.
See, and that's one of the major criticisms from Canadians of the program is that it's almost incestuous, because the very people that receive the funding are also involved in the decision-making process and the governance of the court challenges program. And I did want to also, I just wanted to make a comment on some of your earlier comments. You had made the statement that you believed that the CTF, the Canadian Taxpayers Foundation, was way off base. And then you went on to attack the current government, the Conservative government. And I found it quite, actually, profoundly presumptuous that you would suggest those of us on the government side either have a gross ignorance of the law or that somehow we're involved in some level of doublespeak. I can tell you for myself, I have a pretty good understanding of the law, coming from a legal background myself. So it's not a matter of legal ignorance. One second.
Yes. Hasn't asked a question. I believe that's the intention of having witnesses, is not to make speeches, but indeed to ask a question.
Mr. Chair?
Could you direct him to do so, please?
I'm sure there's a question forthcoming.
There is a question forthcoming, and I also remind the Chair that Mr. Julian many times has waxed eloquent in his introductions to questions and in prefacing questions. And I'll go on to say that I find it very of great concern that you would infer motives to either an organization like the CTF or this government, which you have no proof of. Now, I did want to ask a question of Mr. Rollison. Mr. Rollison.
Question, please.
Mr. Rollison.
Just a question.
I want to assure you, certainly the members on the government side of this table have a great deal of empathy for you. And I'm glad that you were successful in the process and in asserting the rights that your daughter has for assistance. Now, I just want to clarify. The quashing of your rights, your daughter's rights, took place not under a conservative government, as perhaps Mr. Julian wanted to suggest. That occurred under the previous Liberal government. Is that correct?
Yes.
All right. And I think your concern is that that might reoccur if there wasn't a challenge of those kinds of actions.
Yeah, it doesn't matter what stripe of government
exactly.
is. That no matter what you do around this table, whatever other committees do around the table, mistakes can be made. People might just not dream of the possible ramifications that could be out there.
What I did want to do is ask you as well, are you aware of the announcement that Finance Minister Flaherty made this past week about a study that was done regarding the disabled?
Yep.
All right. And today he actually commented on that in question period in the House of Commons?
Yep.
Yeah. And essentially the government, in his response he states, government must better enable parents to set aside funds to financially support a child with a severe disability when they are no longer able to provide support. I look forward to reviewing the panel's advice on how this objective could be achieved. Have you had a chance to review that instance?
Pretty well to the other question.
I just asked the question. Thank you.
You can leave. Yes.
We on this side have been rather respectful of the proceedings of this committee in terms of questioning witnesses and so forth. I'd invite the members of the government side to be as respectful of the proceedings.
With due respect, Mr. Chair, I do recall that that very member has on occasion taken members or witnesses to task for statements that they've made. I've taken the opportunity to do the same thing. I've asked the question of Mr. Rollison. I would appreciate if the member, Mr. Belanger, would not interrupt when I'm questioning a witness. I haven't interrupted him. So again, Mr. Rollison, the question is,
bring your question quickly.
Do you believe that moving forward with some of the recommendations of that expert panel would be helpful to the kinds of challenges that your daughter faces?
It would be helpful that, say, there may be some things I don't know about. Certainly, from what I understand, it's like an RESP program, which means any money that goes into it is after tax. It may be, from my point of view, better if it was like an RSP program, but on the other hand, we have income, so we're able to put money into it. Other people who don't have income might not be able to put money into it. But in terms of like ourselves, I can't forecast what 2-3 years now, if this was become policy, what another family might find in the program that maybe just like mine with the EI, the change from UIDI, maybe there's something else that would come out of that that might not help a family out there. I just can't say for sure.
Well, hopefully our government won't put any others in that position.
Okay, thank you. Mr. Scarpellegio.
Thank you, Mr. Chair. I just want to say that I'm a supporter of the program. I'd like to make that statement at the beginning. It's my understanding that when the impetus for the creation of the program in '83 or '82 was to give official language minorities in Canada the power to ensure that the rights, their rights as clearly stated in the Charter, would be respected. That's my understanding of the impetus for the program. As a Liberal, I believe, I guess the only point of ideology I have is that no institution is perfect. By definition, I will never accept that an institution is perfect and that it can't be reformed and made better to adapt with the changing times or whatever. my question, I guess, it revolves around some of the criticisms of the program, namely that it's some of its decisions may be arbitrary. Certain people's applications are rejected while others are accepted, and I don't have a real strong opinion on that. But do you believe? My question is actually to Ms. Tai. Do you believe that there is any way that the program could be improved? I'm not at all in favor of abolishing it. I'm in favor of improving it. But do you see any need for reform? For example, and it's been brought up before, this idea that people who sit on that there might be some kind of revolving door. I don't know. That's why we're having the program officials come, and I can commend Mr. Bélanger on making that request. But there might be a revolving door between the board and some of the groups who benefit from the program, and you yourself have gone from one to the other. Maybe perhaps we should have a board that is made up of former justices, or like we do with immigration judges, where we have people who are, members of the Order of Canada and bring a certain impartiality. So I guess my question is, do you acknowledge any of the criticisms of the program that perhaps in some cases the program has a bias, or its decisions have been arbitrary, or in other words, can you step out of your particular interest and see a need for some kind of reform?
I'd like to say two things. Firstly, the expert panel is appointed that doles out the money. The board has absolutely no say in how that money is dispersed. There is no overlap. I never had anything to say in all the years I was on the program about what cases were going to be funded. Secondly, many cases are turned down. I, however, fundamentally think that the people whose interests are affected should control the organization that decides what litigation is going to be done. That is the program's strength, not its weakness.
No, I understand that, and your point is well taken. But we live in a world where where there's a certain vagueness as to whose interests should be served and so on and so forth. I'm just saying it's an imperfect world, and it's not science to say that my interests or somebody else's interests are the primary interests, and therefore they should be represented. But thank you for your clarification about the expert board and the difference between the board and the expert committee. I appreciate that. But anyway, that's essentially the point I wanted to make and the question I wanted to ask.
Actually, I think your idea is interesting, but I think it would be quite challenging in this country to find a panel of perhaps ex-judges who represent, so we'd need to find ex-Aboriginal judges, ex-judges of color, women judges, judges with disabilities who then have the necessary qualifications to actually adjudicate. I think that would probably be quite challenging in this country, and that's unfortunate.
Perhaps, but
it might be something quite worth considering for the program as an advisory.
But I guess going back to my
capacity.
original question, do you see any need for reform of the current program? Because I think it might be in your best interests and in the country's best interests if we could come up with an agenda for reform that could save the program. That's basically the point I'm trying to make.
As I said, I'm no longer on the board and I don't speak for the program, but we just went through a heritage review of the program, which made some suggestions for improvements, which we quite happily initiated. I was quite comfortable with how the program came through the review. The Heritage Review said we get value for money for this program, and it's serving a very important Canadian government purpose in the
I understand that, and I agree with that.
So
I agree, but there were recommendations for reform?
I don't have any right now. Sorry, I didn't.
No, but in the review were there recommendations?
No.
Okay.
Which one are you referring to?
The heritage
one. Okay. Sorry.
Anyway, that's fine.
Whatever.
I think that brings an end to our question for this section. I thank our witnesses very much for coming today and bringing your viewpoints to the committee. We'll take a 5-minute break and wait for our next witnesses. Thank you. call the second part of this meeting to order, if we could, and welcome to our witnesses for this session. And I guess we'll start off. We have two people here as individuals, Giselle Lalonde, and then we'll carry on with Mr. Casa, is it? And we'll work our way along the line. So each individual or representative of an organization can give their viewpoint. So, Ms. Lalonde.
Merci. Thank you, Mr. Chair.
Thank you, Mr. Chairman. We come before you today to raise our concerns about a government decision whose consequences are so disturbing that we find it hard to believe that the decision makers gave any serious thought to its impact before making it. The Harper government's decision to abolish the Court Challenges program has a direct negative impact on Canada's linguistic duality, a direct impact on the assimilation of minority francophones, and assuredly, over time, an impact on national unity. For it would be irresponsible and foolish to believe that the Government of Canada can disrespect linguistic minorities in such a way without undermining the very foundation of this country. The media tells us that this brilliant idea is owed to Prime Minister Harper's Chief of Staff. If this is true, what we have before us is a government of ideologues, not to say demagogues. Such a situation such a state of affairs, is extremely troubling to Canadians. Narrow-minded ideology, unrestrained demagoguery have never, ever contributed to building today's Canada and, in fact, are the ideal recipe for its eventual dissolution. We are told that this demagoguery is taken from a certain text published by the said Chief of Staff of the Prime Minister, a book in which he maintains that it is ridiculous for the government to give money to those Canadians who want to bring it to court. Such warped logic is a distortion of reality, and it is scary, very scary. First of all, when a minority decides to bring the government before the courts, it does so because it is convinced that this government is breaking the law, usually the Constitution of Canada or the Canadian Charter of Rights and Freedoms, which means that the direct effect of the Harper government's action is to give itself the power to break the Constitution of the country without anybody being able to contest it legally, the financial burden being too great.
The help of the courts, it is always as a solution of last resort, which means it has tried to make the government understand by every other legitimate means. And thirdly, if by chance a minority manages to raise enough money to dare go before the courts, the government defends itself with our money. How many millions did Ontario taxpayers pay to cover the Harris government's legal costs? And all this to bite the dust miserably twice. The Franco-Ontarian community and the Montfort Hospital did not waste taxpayers' money in legal. We upheld the law of the land, but the Harris government did exactly that. And any government in the country will do precisely the same thing without any hesitation or obstacle the next time it happens. Ce que le gouvernement Harper nous demande.
What the Harper government is asking us to accept, however, exceed in its deceit anything any other government may have done in the past. They are telling Canadians that they have a monopoly on all power, on all truth, and on all rights. Let ordinary people fend for themselves. This is not just a matter of cutting expenses. The Harper government is depriving the most vulnerable in our society of access to the justice system. The forsaken of society are beaten down even lower in the social order. This is not the Canadian way of doing things. It is not a shame, it is a scandal. It goes against everything Canadians believe in, starting with access to justice for all. I cannot remain silent on the role played by Treasury Board Chair Mr. John Baird in this affair. If anybody should know the impact, not to say the illegality, of depriving the Francophone minority of such an essential tool, it has to be him. He happens to be the Minister for Francophone Affairs in Ontario in the worst days of the Montfort crisis. And it was only at the very end of this 5-year struggle that he finally sided with the Franco-Ontarian minority, after we had won in court for the second time. Allow us to doubt his sincerity, then and now. I will tell you about an exchange I had with Mr. Baird back then. I have never spoken about it publicly before, and I regret having to do so today, but he leaves me no choice. The day before the Harris government was to announce it would not seek leave to appeal before the Supreme Court of Canada, Mr. Baird called me at home. During that brief conversation, he kept telling me that we had to turn the page on the events of the previous 5 years. He repeated that phrase several times. The action he did today as the chair of the Treasury Board is that he turned a page, but he certainly does not have the same book I have. The only conclusion we can draw from Mr. Baird's actions is that if he can't get the French one way, he will find another way to do so. There are many ways to kill a people. It would be rather surprising to learn that this decision was imposed on Mr. Baird from up high, if one has to judge by the ferocious defense he mounted for it in the House of Commons. The most deplorable aspect of his involvement is that once again he is part of a government that seeks to score points with the electorate by attacking the most vulnerable in our society. I dare say, however, that his government has radically misread the Canadian electorate. This is particularly true of Quebec voters. We strongly suspect that in its cold calculations, the Harper government concluded the Francophone Quebecers would not oppose his decision since the court challenges program protects its Anglophone minority. But Quebecers see clearly. They understood right away that the real targets of this decision were their minority Francophone brothers and sisters. And as they rose thunderously to support Montfort, they will not forget this further injustice when the time comes to settle the score. One thing is for sure, we Franco-Ontarians will not let them forget it. We will work feverishly in every riding, including in Quebec, where the vote of Francophones can make a difference. We will ask them to reject a government whose indifference is but veiled intolerance, and intolerance against the weakest. Mr. Harper governs by one rule only, the law of the strongest. This requires no courage. Mr. Chairman, members of the committee, we came to share the indignation of minority Francophones faced with this governmental decision. We fully intend to fight this decision by all legitimate means possible. And to do so, we ask you to continue to work with us as you have done in the House of Commons. And we ask you to make your constituents aware of this and to continue to do so until voting day. Let me say a few words to the party in power. Most of you, if not all, were probably not consulted by your government on this measure. We thank you for consulting us today. We want to remind you that you have a certain weight within your caucus, and you have the duty, when the government gets off track, to bring them back to order and to show them the right road. We hope that you will understand the extent of the damages you have caused to the Francophone minority and the harm you are causing to your own party, that you will act in the interest of linguistic duality, in the interest of all Canadians, and in respect of the Constitution of Canada. Thank you.
Mr. Guest.
Monsieur le Président, in my presentation, because I want to make sure everybody can understand directly and not with the aid of interpretation the message I'm bringing to you today. The reality is that when you are a member of a minority, you need to have recourse to the courts because the protectors of minorities are not the majority. The majority, and it's not because they're acting in bad faith, it's because they don't understand the needs of the minority. So for the last 200 years, minorities have had to have recourse to the courts in order to make sure their interests are protected. And the courts, one of their main responsibilities is protecting minorities. And to have access to the courts, especially in issues of constitutional law, you need to have a lawyer. And what's special or different about linguistic rights is that the people that are going to court in order to have those rights defended usually have a very small personal interest. It's a community right. And so when they go forward in order to bring that right forward, they do not get any money in return. All they get is the respect of a right, which is why when they have access, when they need to get access, is the only way to get their rights respected. They have to proceed by way of the courts. They need to get the financial assistance. And the reality is that when you're dealing with linguistic rights, the consequence of people not coming forward in order to make sure their rights are respected affect everyone in Canada. Because a linguistic right, the reason minorities go to court in order to have their linguistic rights protected is because as a minority, and it's important to understand what a minority does and how a minority lives. When you're a member of a linguistic minority, especially the Francophone minority outside of Quebec, every time you get up in the morning when you wake up, you decide that you're going to continue making efforts to live in French that day. And when you stop making those efforts is when you have assimilation. Assimilation of Francophones is simply Francophones that stop making the efforts they have to make in order to continue living in French. And it's an essential characteristic of Canada that linguistic communities, linguistic minorities throughout the country be able to continue living in one of the two official languages. When members of the linguistic minority, and they can be in Prince Edward Island, Vancouver, Kapuskasing, Sudbury, North Bay, Windsor, when they go before the courts, what they're saying is there's a government decision or a government law that is telling us that we should not be making the efforts to continue living in French. That's why we go before the courts. Because when that law or that decision continues to stand, every day there are members of the Francophone minority who stop living in French. And the result is we have weaker and weaker linguistic minorities throughout Canada. And the Supreme Court of Canada has stated that linguistic minorities are an essential feature of Canada, that the survival of linguistic minorities in Canada is essential to the survival of Canada as a country. And when the court challenges program is cut, what they've cut is the access of very ordinary people to the judicial system in order to have those rights respected. And the consequence, and it's a direct consequence of having cut the court challenges program, is that the assimilation rate of Francophones throughout Canada, outside of Quebec, is going to increase. And that is an irreparable harm to the community. It's an irreparable harm to the country. That's why the court challenges program is essential for Canada, and it must be reinstated. Thank you.
Thank you.
Bonjour, Mr. Chair. Bonjour, mesdames.
Hello, Mr. Chair, ladies and gentlemen. My name is Gisèle Saint-Amand. I'm the Director General of the Commission scolaire de la langue française de l'île du Prince-Édouard. I'm in my 43rd year of education, 20 of these years as Director General and Senior Manager. I'd like to tell you about what I am doing. I am not here as a lawyer, I'm not here as a journalist, nor as a political partisan, but as a Francophone first and foremost, living in a minority setting. I've lived 20 years in Quebec. My two children are Anglophone rights holders in Quebec and Francophone rights holders elsewhere in Canada. So I'm here to plead on their behalf and for the return of the Court Challenges Program. The benefits of Section 23 haven't been fully reaped, and I'm not the first person to tell you this. I'd like to thank you for the time you've given me. I distributed a brief, which I'm certainly not going to read aloud. I think that you got this brief. I was told that it would be translated into English. As an educator, I've always had the same mission, and that is to build a better world. And it is in this capacity that I am here today. I have been part of all the epic struggles to have the right, the pleasure and the joy of speaking in French, and to give the same right to my children. I am working hard to ensure that all children of Francophone rights holders have this right. Too many efforts, far too much work has been done for us to lay down our arms today. And it's an excellent opportunity to come before you today to say to what extent we condemn the government for the action it has taken today. This is an excellent opportunity. So an opportunity to go before the courts isn't an opportunity that everybody has. Often the rich only get this opportunity. This is why this CCP enables everybody to be on an equal footing and provides for an equal playing field. I am here to talk about the children of PEI principally, those that are at school currently. You're sitting in a comfortable chair. I have students in PEI today that don't sit in such comfortable chairs. These children didn't go to school in a comfortable school bus. They don't have a comfortable school in the sense of the sort of school that you went to. There is a lower court challenge currently to force the PEI government to uphold our constitutional rights. This particular school is in a building which is shared with a bar. In my brief, on Thursday and Friday nights, those that go to the bar visit it from 3 p.m. and afterwards. So the next morning when I come to school with the children, there are things that don't belong to the school kids. There are cigarette stubs that don't belong to these school kids. So I would like to refer to the Arsenault-Cameron decision, which stated that minorities in PEI should have 3 rights, and these are crucial key rights which are non-negotiable: quality education, equal education, and school governance for and by Francophones. I just described a school where we aren't entitled to hire a concierge. I've just described a school where we aren't entitled to be there in the evening without reserving the space ahead of time. And if someone else reserves this space, we are uprooted. We have no right to provide our input. We have no right to veto decisions in this school. This case was before the courts to ensure that we would get the same rights in this school as the rights that the majority schools enjoy in PEI. I'd like to take a couple of minutes now to talk about the funding available in PEI. The French language school board, which employs me, looks after the East and West. PEI is a French language school board, as I said, and the schools are very much dispersed and far apart. The funding that we get currently isn't enough, despite all our efforts, to provide high, top-quality education that the Arsenault-Cameron decision referred to. For the students of PEI, well, I have the sense that the government of my country, a country that I'm proud of, wants the same as I do. That is equal education for minorities that the majority enjoys. And yet, in PEI, if we don't have the opportunity to advocate for our rights before the courts, and I'll tell you straight away that 3 of our schools, we have 6 schools, 3 of our French language schools came as a result of the struggles that were funded by the CCP. So without this program, I fear that our rights under the Charter will not be upheld for some PEI Francophone communities. We quite simply don't have the money to go to court. The funding that we do get is public funding. School boards are funded through government budget envelopes. So in closing, we had a number of parents who were getting ready to go to court to have their constitutional rights upheld. These parents live in Ristico in the north coast of PEI, and these parents would really like to have their constitutional rights upheld so that they can give their children what your children benefit from and enjoy in majority schools. At the French language school board, even though that we sit on the same at the same table as the two Anglophone school boards in PEI, we do not get the same funding. The French school board and its many challenges aren't taken into consideration when funding is concerned. So the Anglophone students have fewer challenges and get the same funding. So put yourself in the shoes of these parents. If you had a choice to make, what school would you send your children to? And I fear, as my colleagues have stated earlier today, that unless we can ensure that the Arsenal Cameron quality, unless we can ensure what Justice McQuaid said at the Supreme Court, unless we can ensure that there is a equal level of education, one that isn't inferior to that of the majority, then the Section 23 rights will not be upheld. This is a Supreme Court justice which said this. I don't know what political stripes he has. I'm just asking you to consider me as an educator, first and foremost, here to advocate for the rights of Francophone school children in PEI. It's often said, and I'm always glad to hear it, that Canada is the conscience of the whole world. Each and every time I hear that, I'm proud. And right now, I think we have a problem with our conscience, and we have to look hard at our conscience in Canada. This is a plea that I'm making before the members here today. This program should be reinstated as it was before. It may be changed, but I beg you, on behalf of these children, on behalf of the PEI students, give us the opportunity to go before the courts and start legal action each and every time, and it occurs often, that our constitutional rights aren't upheld. The Canada of tomorrow will look exactly like the children that it is educated by. They will be the mirror of Canada's future society. So let's give our children a strong Canada, a proud Canada, based on the values that I have adhered to in raising my children. That is an open Canada that respects all groups, whichever they may be. Thank you very much, Mr. Chair.
Tabachnik.
Thank you. Good afternoon. I'm Marcus Tabachnik, President of the Quebec English School Board Association, and I'm accompanied by David Birnbaum, I should know his name, by David Birnbaum, who is our Executive Director. Monsieur le Président, Mr. Chairman, members of the Standing Committee, the Quebec English School Boards Association thanks you for this opportunity to present its views in support of the reinstatement of the Court Challenges Programme of Canada. Our association is the public voice of Quebec's 9 English school boards, serving some 115,000 students across the province. The English Public School Network of Quebec offers a portrait of Canada's English-speaking minority community in all its diversity. There are one-room schoolhouses on Entry Island in the Île-de-la-Madeleine and in Vaudreuil, just 45 minutes from Montreal, big city high schools, regional adult education centres, and every variation in between. For many of our students, the daily trip to an English school is an hour and a half away each morning. There are big challenges, but I would tell you that our system is addressing them with ingenuity and determination. It was in our schools that French immersion was born and perfected. Today, we pride ourselves in producing graduates who are building their futures in Canada's 2 official languages. Nos écoles, comme celles des communautés francophones.
Our schools, like those of Francophone communities in the rest of Canada, are so often the glue that holds our minority language communities together. Of the 340 schools in our system, more than half serve 200 students or less. The future of those schools and the future of the minority language communities they serve is inextricably linked. Consequently, our school network and our association which speaks for it are vitally concerned by the subject before this committee today. That is because there is also a link that connects us to the future of the Court Challenges program.
Elected level of government, the only level of government that answers directly and exclusively to the members of Canada's English-speaking minority community. This level of government, elected school boards, has the right to control and manage schools serving the minority language community of Quebec. School boards exercise that right by virtue of decisions rendered in landmark cases made possible by the Court Challenges Program of Canada. The rights of students to attend minority language schools is also a question which the Court Challenges Program was created to help answer. In Quebec, access is limited by the Charter of the French language, but nevertheless protected within those limits under Section 23 of the Charter of Rights and Freedoms. If individuals are to test the extent of those constitutional protections against the formidable resources of government, they must have the right to do so. The Court Challenges program is a meaningful and reasonable way to ensure that right. The Charter at Section 24(1) says, anyone whose rights or freedoms, as guaranteed by this Charter, have been infringed or denied may apply to a court of competent jurisdiction to apply such remedy as the court considers appropriate and just in the circumstances. For many individuals and communities in Canada, that recourse is only real if financial support is made available. For many individuals and communities, that recourse will only be available if the Court Challenges program is reinstated. L'article 24.1 de la Charte précise toute personne victime.
Section 23 specifies that any person whose rights are infringed upon, that are guaranteed under the Charter, may go to court in order to seek reparations that a court considers right in these circumstances. For many communities in Canada, this can only take place if a financial support mechanism is available. For many people and communities, this recourse will only be available if the Court Challenges program is reinstated.
Circumstances affecting minorities change. The Charter of Rights and Freedoms must be tested by those changing circumstances if its full breadth is to be clear and meaningful to all Canadians. In the seminal Mahe case on the extent of control and management of schooling afforded minority language communities in Canada, the Supreme Court said that continued recourse to the courts would likely be required if the application of the Charter was to be fully effective and equitable. The judgment said imposing a specific form of educational system in the multitude of different circumstances which exist across Canada would be unrealistic and self-defeating. And the same judgment continues. Section 23 is a new type of legal right in Canada and thus requires new responses from the courts. The future of the Court Challenges program has been falsely framed in some quarters as a question about special interests, as an infringement upon the supremacy of Parliament, as a cash cow for big city lawyers. Those suggestions, as facile as they are disingenuous, were pretty much summed up by a senior member of the current cabinet. In defending the cancellation of the program, he was quoted as saying, "I just don't think it makes sense for the government to subsidize lawyers to challenge the government's own laws in court." It is often said that a democratic society is rightly judged by how it treats its minorities. These are not partisan questions about challenging the government of the day. They are matters that go to the heart of who we are and how we define the fundamental rights and freedoms that unite us. The Court Challenges program isn't about subsidizing lawyers. It's about ensuring equality before the law and guaranteeing equality of access to the law. Les Québécois, peu importe la langue parlée, sont peut-être
Quebecers, whatever language they speak, are perhaps particularly exposed and sensitive to minority language matters. Consequently, the cancellation of the Court Challenges program has been greeted with much opposition in our home province.
Been greeted by much opposition in my home province. The chief editorialist of La Presse newspaper in Montreal noted, sans l'aide financière du gouvernement, quelle personne
Without the government's financial assistance, which groups or persons will be in a position to spend the hundreds of thousands of dollars needed to pursue a cause, right up to the Supreme Court? Given the unlimited government resources, citizens who believe that their rights have been violated will feel helpless. Consequently, what is the value of a Charter of Rights if citizens do not have the means to ensure that it is upheld?
The Court challenges that legitimately warrant additional scrutiny? Quite possibly. It is not for QESBA to judge, but as M. Pratt concluded, Ottawa a décidé de soigner une grippe en tuant le patient.
Ottawa has decided to cure the cold by killing the patient.
That's a pretty dismissive way for our national government to discharge its solemn role as custodian of our Canadian Charter of Rights and Freedoms. Pour les parents anglophones en Gaspé, pour les membres
For the English-speaking parent in the Gaspé, for the English school board member in the Saguenay, not to mention a francophone community leader in Alberta, this program is their doorway to Canada's Charter of Rights and Freedoms, and that charter remains the penultimate guarantor of their future.
The English school board member in the Saguenay, not to mention a francophone community leader in Alberta, this program is their doorway to Canada's Charter of Rights and Freedoms. And that charter remains the penultimate guarantor of their future. The Quebec English School Board Association calls upon this committee and this government to do the right thing. We call upon you to reinstate the Court Challenges program. Merci. Thank you.
Thank you very much. Mr. Boulanger.
Thank you, sir. I have people know by now my usual first question. Madame Lalonde, Madame Saint-Amand, and to you, Mr. Tabachnik. In the occasions where you may have had support from the Court Challenges program and could hire legal representatives, lawyers, was the political affiliation of these lawyers a matter of consequence in your choosing them?
You mean to say, like at Montfort, if we had chosen someone who was close to the government? Or?
No. Est-ce que l'affiliation politique des avocats?
No. Was the political affiliation a factor in the choice? No. No, as far as I know, not at all.
The lawyer who was best able to represent us, and that's the only criteria by which we judge.
Thank you. And also in justifying their decision to close, to cancel this program, le gouvernement a dit
the government stated that they had the intention of only tabling constitutional bills. That's always the intention of governments, but it's up to the legislator to decide whether or not they are, and then following that, the courts. What I'm trying to get to is the scope of the Court Challenges program. With the scope, am I correct in saying that it goes far beyond an issue of the bills tabled in the House? It applies to existing legislation. It applies also to provincial laws and the bills that they can introduce and enact, and also to actions taken or actions that are not taken. For example, in PEI, where there was a refusal to build schools, and that was an example of non-action by the government. So in your opinion, does the Court Challenges program go beyond the issue of the bills that the federal government may table? Well, Mr. Bélanger, I believe indeed that the federal government has certain powers, and there are powers in the province as well. What minorities really need is education, health, and social services, above all. And if the federal government, even if it's the best government in the world, can be dealing with a provincial government that doesn't respect those rights, which happened exactly in our case. They weren't respecting the francophones of the province. So at that point in time, what we expect from the federal government is that, first of all, they come to our assistance because they have the responsibility to protect minorities. So what we expect is that they will come to the assistance of that minority, certainly through the Court Challenges program, but also through mediation or through correspondence with the province, with the people involved. So I believe that the federal government, the current one with Mr. Harper, takes it for granted that everyone is going to do the same thing as him and be very careful not to hurt the minority. In the case of Prince Edward Island or in Alberta, where there are not enough French language schools, they have nothing. There was a program on Radio-Canada CBC the other day, and they were saying it's not reasonable what's going on there. And in this instance, it's the Alberta government's that's responsible. The federal government has the responsibility of helping the people there, help them to deal with the provincial government at that time. So don't try and tell me that our money, the money that's taken, it's our money in any case. The money that we've been given is our own money as well. So it's crazy to say that when we're fighting against the federal government, they come with legions of lawyers.
4 or 5 lawyers when they come to court, and they have lots of money. But we have 12 lawyers that really work together and have chosen Mr. Kaza here to defend our cause. And we have only the money. We didn't have the whole money to pay him, but this program helped us. And we cannot think of another cause. And we are in the capital of Canada. And we have the greatest majority of francophones out of Quebec in Ontario, and we have half of this group in the region of Ottawa. So we were lucky in to get some money out of those people. But it's not everyone. There's one in Penetanguishene right now, and they don't have any money. They have one in court. But still, the government, this is the government of Canada, by the way, the industry, they don't give them the money they need. They never had a project for the francophones over there. So, you know, these are injustices that are made sometimes by the federal government, but most of the time by the provincial governments, and we need to have help. And this is your responsibility. This is your role.
If there's anyone else who's going to answer to that very briefly, because we only have 15 minutes left.
Mr. Chair, if I may just briefly, the Mike Harris government never thought that they were acting illegally and that they were acting unconstitutionally. And in fact, if you look at all the legislation that has been set aside as a result of the Court Challenges program, never was there a government that purposely set out in order to violate linguistic rights. None of them. They all felt that what they were doing was legal, but it wasn't, and it was up to the courts to make that determination.
And I would add that the Court Challenges program has an active impact, that is to say, when we appear before the courts. But there's also a really incentive, there's an aspect of it that's like an incentive. My country, my government has the right to respect my constitutional rights. And they did so by setting up the charter, by entrenching it in the charter.
Adopt a non-constitutional legislation is an absurdity. Is that to question that the judiciary is no longer a legitimate and vital branch of democracy? So that leaves us rather speechless. Second, if you look at the importance of this program and its potential importance to Canada's English-speaking linguistic minority. There hasn't been occasion yet, and we hope there won't be, to test Section 23 in its full breadth with respect to the existence of English-speaking communities on the mainland and the school boards that support them, because there are endless examples in Canada that show that those communities will not exist if their schools are not there. So that program is important to us for something we may have to have recourse to many years from now or next year. But it's impossible to separate the Charter from this program. If this government is to suggest that the Charter is, of course, a legitimate part of our fabric, our legal and political fabric, and its role is to defend that Charter, the Charter only exists if one has recourse to it, and thus the program is essential.
Okay. Thank you very much, Mr. Coteau. And we have to try and keep some of this brief because we've only got about 10 minutes left.
Good afternoon and welcome, ladies and gentlemen. You have realized, as have we, that the Conservative government has abolished initiatives for volunteerism. They changed the Status of Women program to prevent certain advocates from receiving money in certain lobby groups, and now it has eliminated the Court Challenges program. So from our perspective, we are faced with an ideology that is bringing us to a world where there's a kind of Darwinian psychology that is prevalent. Does that not concern you? I ask the question because unless we are corrected on this by actions that may come in the future, I'm afraid that this program will not be reestablished. And if that is the case, what do you intend to do? Well, I can tell you that we fought for 5 years to save an institution. We fought for regulation number 17 in 1997. We fought for Francophone schools in 1919 until 79-80, and what governments often try to do is to wear us down and to exhaust us. And I'm sure that over the 5-year fight that we had, the Ontario government was quite certain that we wouldn't make it to the finish. It was very difficult indeed to keep up the momentum. It's hard when you are fighting that kind of a fight. So we will continue, and we will use the means that we have. And I hope that the government will reflect on this and rethink what they've done, because it makes no sense what they've done. You can see Mr. Harper, who speaks French very well. He's an able man. He can understand us. So why, in this day and age, he's hurting all of us, all the most vulnerable elements of society, women and children. I find it really hard to understand that a government that's not on the hard right will do things like that. If I can just add something briefly, that is the message that's being sent to both English and French minority language groups. It's a simple message. By canceling this program, the Court Challenges program, there's no point in continuing to make any efforts to preserve your situation. When you ask what the impact is, the impact will be a rise in the assimilation rate in Canada. All of the small communities in the country are already fighting hard to keep what they have, and the government's message is that it's no point in continuing the fight. Well, I don't think I can really add to that except to say that the first mandate of a French language school is to be a tool of renewal for our community. The future of the francophonie is closely linked to the access to and the success of francophone institutions. So, Mr. Coteau, perhaps I am an eternal optimist, but I cannot reconcile myself with the idea that my government is going to ensure that I am beaten down. In 1955, we were hit hard. We were hit, and today we have been left on the sidelines. This has to be corrected.
so much what we'll do. We're going to keep moving forward. Every association will, every community will do what it can to protect its future. But I think it's the message that comes out of this, and the message to minorities, the English community in Quebec. This attacks the very heart of what this country is about, and that's protecting the people who need the ability to be protected. And this is the court of last resort. It's not something that anybody runs to in the first instance. It is a last chance opportunity to protect the rights that you have as a minority within your community. And what we're being told is, well, it's too bad you don't need that.
Okay, thank you. Very short.
You alluded to Section 23 of the Charter with good intention. Some who oppose the reestablishment of the program are referring more to Section 15 to justify the fact that this, or saying that the program contravenes that section. So do you have a comment on that? As to whether there's a conflict between those two sections, the 15th and the 23rd? Well, just that's their opinion. They're using Section 15 to support the abolishment of that program. These are the groups that are challenging the credibility of the program. Well, all I can tell you, 15 and Article 23 are certainly different things. Section 23 is there to protect the minority, and the majority doesn't need that. Well, you don't need to convince me, says Mr. Coteau, I'm playing the devil's advocate. Well, there's nothing more unequal than treating people who are unequal in the same way.
Mr. Julian.
Thank you very much to the witnesses to coming today. You've been very eloquent. I just wish that half the Conservatives on this committee weren't missing, because I'm sure they would have learned from your testimony today. I'd like to go to Mr. Tabachnik and Mr. Birnbaum to start, because in a very real sense, what you're talking about is the choice available to parents. I think Mr. Rollison spoke to that earlier, that the parents who are in a dilemma where the government is refusing to give them the choices and the rights that they need to have for their children, that essentially by eliminating this program, those parents collectively won't have an opportunity to fight for those choices for their children. Would that be accurate, an assessment, that this takes away from parents actually being able to choose what's best for their kids through assuming their rights and reinforcing their rights?
I would agree with your statement, but I don't know how many of you have ever tried to close a school in somebody's neighborhood. I can tell you that I have lots of experience in doing that. Parents will do a tremendous amount, and communities will do a tremendous amount to try to save their schools. What you have, and they have recourse against a level of government that school boards are to the courts, and they make use of it. Trust me, I can attest to it. However, what you're saying then on the bigger scale is that that ability isn't available to the community as a whole, as it is affected as a whole. That's not acceptable, that one level of government is not allowed to be questioned on whatever program, for whatever reason it is decided to put into place in law. We need the ability to challenge ourselves in order to ensure that what we're doing is best for everybody.
Merci pour ça. Maintenant, j'aimerais revenir.
Thank you for that. Now I'd like to come back to what Madame Saint-Amand, Ms. Lalonde, and Mr. Caza raised. And indeed, for Francophone groups, these are Francophones who pay taxes, who fund the federal government. The government can use those same resources to crush those minorities if they want to, and that seems to be the direction the government wishes to take. But the Francophone minorities don't have the opportunity to equalize that situation. They don't have the resources to do so. So do you believe that the Conservative government's decision has really been made on the backs of the Francophone communities and the other minorities like the English-speaking minority in Quebec? Well, you know, when we want to collect money for whatever the issue may be, as it stands, I'm the vice president of the Foundation for the Francophone Hospital. It's very difficult for Francophones because we don't have any big groups outside of Quebec. In Montreal, they have Saint-Justine and major hospitals of that nature. But when we speak to the Anglophones, we have difficulty with the big hospitals here, the Heart Institute, the Civic, the General, the Children's. So we're the little Montfort hospital, the little Francophone hospital, and we're trying to get money from the same sources as them, and it's difficult. But we don't, if we have the same sources, clearly it's not easy. We even crossed Canada to collect money to try and get ourselves out of the situation. So it doesn't make any sense. It's unthinkable how a minority group, how they're supposed to fight against a strong government, whether, say, it's in Ontario or Alberta or elsewhere.
I'd like to add something. We should disabuse ourselves of the idea that we are defending a program that only benefits minorities. There was a poll in Quebec a few years ago. The question was asked in Anglophone minorities, should they get essential services, for example, healthcare services in their own language? And the vast majority of Quebecers, regardless of the language, agreed. And I think it's important that we stress the fact that this is a program which is dear to all Canadians, whether they are minority or majority members.
Record from our non-partisan point of view, our observation about the lack of participation from the government side today. Thank you.
Thank you. Mr. Fast.
Chair, and I wanted to, first of all, just thank all of you for attending today. I did note that there appears to be two approaches amongst your group. All of you are defenders of language minorities in Canada, but a couple of you have clearly taken a partisan position, certainly the first speaker. But I did notice that Ms. Saint-Amand and also Mr. Tabachnik, both of you referred to this as a nonpartisan issue, as did Mr. Birnbaum, right? And I do appreciate that, because this is not a party against party issue. It should be an issue of policy that we can discuss and debate. And I suppose the question I would have, first of all, to all of you would be, are any of you aware of language minorities which have actually sought to assert their rights in the courts without CCB funding? Are there organizations that defend minority language rights that have done so without accessing the public purse?
Well, we're an association that defends a right, but we don't have the means to fight it in front of the highest court of the land to get a definitive final decision on the applicability of any particular law.
But I'm wondering, are there some individuals that have moved forward and have actually been able to do it from their own resources? That's a legitimate question to ask.
And it's happened.
What about Mr. Kaza?
Well, I must say that I think it's very rare, and the time it would happen, I'll give you an example, is if a union was involved in a file. I'm giving you that as an example. While they may have the financial means to be able to litigate it, that would be an example. But to have sort of, if you look at all the case law on which we rely when we go to court, I don't think there's any case law, and I mean, I'd have to think back where there was no involvement at all from the Court Challenges program. People have had to go beyond it on some occasions, but I'm not aware. What
about the Quigley case, which I think, Mr. Kaza, you were involved with, and I think Mr. Belanger is very much aware of it. I believe that was a situation where an English minority applicant applied to the program, to the Court Challenges program, and was not successful in obtaining funding. And that individual did pursue the matter through the courts, through the help of other individuals.
Well, I'd have to go back. I must say, I'd have to go back to the Quigley decision. But I may be wrong here. But I think the lawyer acting on behalf of Mr. Quigley was his son. But I mean, I could be wrong. I'd have to look into that. And I think he took the case. And there were issues of legal fees. And I'd have to see as to what happened at the end of the day.
I understand, Mr. Kaza, that there were legal fees in excess of $100,000 that were incurred, which were borne by a number of individuals. So It is possible.
Well, yeah. Oh, and I must say, I got to tell you, I mean, if somebody out there is willing to spend their own resources for whatever reason, and they have those resources to spend, I think the issue is that they may have access to the court. And that's exactly what we've been saying. No. Access, yes, it is. Access to the court cannot just be by people who have money. And people that access the Court Challenges program, for the most part, are either organizations or individuals that don't have the money to go to court. That's why they apply. If they do have the funds, and some people may have the funds, I mean, there may be people who have the financial means to be able to litigate a linguistic right, well, they'll have access to the courts. But the situation is, most of the members of the community and people that have, in fact, brought these cases forward do not have the financial means. That's why they're accessing the Court Challenges program.
Perhaps if I could just close with one question. I think this is perhaps a more encouraging, positive question. If our government was able to come up with a plan that would focus on minority language rights specifically, in other words, rather than being a general program defending not only minority language rights but also equality rights and some of the other rights under the Charter, if the government came forward with something that was focused in on minority language rights, is that something that you would welcome?
We would greatly welcome it, with the proviso that, like any law adopted by a government, it would be subject to the full scrutiny of the courts and complete access to those courts. Otherwise, we would have difficulties understanding the full value of that law, no matter how well it was written.
Understood. I'm making that assumption that it would do that. One more.
Could I answer the gentleman? He accused us of being a little partisan. Well, I can say to you that I was a conservative once, and I even ran in Ottawa-Vanier for the Conservatives. And but the bad what can you say? The bad experiences we had. It's been twice at the federal level that it has been taken out, both by Conservative governments.
Mr. Chair, I'd actually.
I'm sorry, but I would like to speak to you. You accused me, and I would like to answer you.
Please, I'd like to have that question answered by Ms. Sanamon.
To answer the question that you asked, I would have to say that I would welcome any law or a program that would help me and the community I represent here today fight for our linguistic rights. But I have a hard time in saying that I don't want other people's rights to be respected as well. And I know that in this program we had means to help women and various other groups to, inalphabet, I'm not sure how that is in English. What is it? Analphabet, that's what it is. En tout cas, analphabet, and I would want all these groups to be represented under the Charter. I really would. Although I would represent, and that's what I'm fighting for today, linguistic rights.
I think we all would have appreciated if that would have been the process from the beginning. Put the hypothesis in front of us, give us a chance to respond, rather than fighting from the other side.
Okay, thank you very much to our witnesses. Mr. Belanger.
If I may, I believe this may be the last meeting we have before we adjourn for the festive season. So on behalf of my colleagues, I wish you and all of our colleagues and the witnesses and anyone who may be listening, un joyeux Noël et une très, très, très bonne année. And I look forward to resuming.
Happy Christmas and New Year.
Thank you very much. And you took the words right out of my mouth. You preempted me. I'm the chair and you're the vice chair. The vice chair preempted me. Again, Merry Christmas to everyone. Thank you. Meeting adjourned.
Yeah, he was too